Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to discuss the June 27th, 2025 ruling by the U.S. Supreme Court in the cases related to President Trump's executive order on birthright citizenship titled Protecting the Meaning and Value of American Citizenship that we covered in episodes 2 and 10. The first takeaway from this ruling is that this was only a ruling on a matter of procedure. The U.S. Supreme Court has not yet weighed in on the substantive issues related to whether President Trump's Day 1 birthright citizenship order violates the 14th Amendment of the U.S. Constitution and a federal statute, specifically 8 United States Code, Section 1401. For context, prior to this hearing, there were universal, nationwide preliminary injunctions in place in 3 federal district courts that previously enjoined the Trump administration from implementing the executive order nationwide. The U.S. Supreme Court ruled that federal courts may not issue nationwide injunctions because the issuance of such injunctions exceed the equitable authority vested in the federal courts by Congress in the Judiciary Act of 1789. Therefore, the court essentially ruled that federal district courts can only enjoin the government from enforcing unlawful and unconstitutional policy against parties who are actually named in a lawsuit who are granted injunctive relief. The Supreme Court noted that class action suits would be a way to obtain injunctions on a larger scale, but that the federal courts lack the authority to issue injunctive relief that extends beyond litigants in a particular case. The practical effect is that, at least until the Supreme Court issues a substantive ruling on whether President Trump's executive order is lawful, parties who do not sue to enjoin enforcement of the EO against them, or parties who do not join a class action to enjoin enforcement of the EO against them, will not be protected by the courts. The practical impacts of this ruling will likely be felt across the country through an array of likely illegal and unconstitutional actions that have come from or will come from the Trump administration. I will read you quotes from the majority opinion that was drafted by Justice Amy Coney Barrett. Quote, "Neither declaratory nor injunctive relief, we have said, can directly interfere with enforcement of contested statutes or ordinances except with respect to the particular federal plaintiffs. It is an elementary principle that a court cannot adjudicate directly upon a person's right without having him either actually or constructively before it. Because the universal injunction lacks a historical pedigree, it falls outside of the bounds of a federal court's equitable authority under the Judiciary Act. Here, prohibiting enforcement of the executive order against the child of an individual pregnant plaintiff will give that plaintiff complete relief. Her child will not be denied citizenship. Extending the injunction to cover all other similarly situated individuals would not render her relief any more complete. No one disputes that the executive has a duty to follow the law, but the judiciary does not have unbridled authority to enforce this obligation. In fact, sometimes the law prohibits the judiciary from doing so. Everyone from the president on down is bound by law. The principal dissents analysis of the executive order is premature because the birthright citizenship issue is not before us. And because the birthright citizenship issue is not before us, we take no position on whether the dissent's analysis is right. I will read some opening quotes of the dissenting opinion that was authored by Justice Sonia Sotomayor. Children born in the United States and subject to its laws are United States citizens. That has been the legal rule since the founding, and it was the English rule well before then. The court once attempted to repudiate it, holding in Dred Scott versus Sanford, 1857, that the children of enslaved black Americans were not citizens. To remedy that grievous error, the states passed in 1866 and Congress ratified in 1868 the 14th Amendment Citizenship Clause, which enshrined birthright citizenship in the Constitution. There it has remained, accepted and respected by Congress, by the executive, and by this court until today. It is now the president who attempts in an executive order to repudiate birthright citizenship. Every court to evaluate the order has deemed it patently unconstitutional and for that reason has enjoined the federal government from enforcing it. Check out episode 2 for a discussion of the substantive issues with the birthright citizenship executive order, which could make its way for final review by the U.S. Supreme Court later this year. Additionally, check out the amicus curiae brief that I submitted in this matter in the U.S. Supreme Court at www.biazzo.com and stay positive. The fight isn't over yet. It's just more challenging now, but it's not impossible. Keep following Executive Coup for further updates on this matter and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.